Hello everyone, good morning. This is Rahul Vadodkar from NIT Raipur 1985 batch. I have started these NITRUS talk series for the benefit of our alumni. NITRUS talks are where we call experts from different fields and share their knowledge with us. These are public talks. These are not private consulting. So although given the professionals, but these are not one-on-one professional advice. So anybody has any questions, they should definitely reach out to the presenters offline and get some more professional help. So today we have the honor of Sunita Dewan ji, Poonam Gupta ji, and Hafizuddin ji. They are from Dewan Law and Associates. Sunita ji has been practicing for a long time. She got her bachelor's in economics and political science from St. Francis College. Then she did her master's in economics from Osmania University in Hyderabad. And then she got her Juris Doctor from Seton Hall, New Jersey. So she has been practicing for a long time. I think I will let her start the meeting. Sunita ji, please take it away.
Thank you, Rahul, for the introduction. Good morning, everyone. I am Sunita Dewan, the founder of Dewan and Associates. My firm was founded over 26 years ago and has worked almost exclusively in the area of immigration. So we do have considerable amount of expertise in the field of immigration. I have with me two of my esteemed colleagues, both of whom are attorneys with over 25 years of experience. Hafizuddin is our managing attorney, and Poonam Gupta is an attorney with considerable legal experience, which is not just immigration, but in the areas of employment as well. We will break this into three segments: employment-based, family-based, and investor-based. And I will let one of them start. Perhaps we will start with the employment-based. We'll speak for about 30 minutes, after which we'll take questions and answers for the next 30 minutes. If I feel that we need elaboration on certain points, I may just intervene for a second and ask our speakers to elaborate as appropriate. So I give the floor now to our attorneys from my team. Hafiz, are you starting?
He's muted.
Is he muted?
I believe so. Hafiz.
Yes. Hello, everyone. Thank you, Sunita. Thank you, Rahulji. Thank you for inviting us to this event. Very pleasure and honor to present here. I'm going to start off with some common non-immigrant visas. Non-immigrant means that it's a temporary visa for temporary purposes. You're coming here to, let's say, study, to work, or to engage in some kind of research activities and so forth. So that's the distinction between non-immigrant versus immigrant, where you're coming in for a green card. Let's say your family sponsored you, or you did an EB-5 or something. That's the distinction: non-immigrant versus immigrant. Let me start with the F1 visa. The F1 is the student visa. That's the visa that allows individuals to come here to study, whether it's attending a bachelor's program, master's program, or even maybe English as a second language. The key requirement for the F1 is what's called non-immigrant intent. The individual looking for the F1 status or visa needs to come here with the understanding that they're coming here temporarily with the intention to go back. In fact, USCIS requires that the person continue to maintain residence to which they intend to return. So the idea is, I'm coming here solely to study and I intend to go back. Certainly, people come in and they change their minds, and that's okay. But the idea is, at the time that you're seeking the visa, your intention should be temporary, to come here to study with the intention to go back. If when you're here, Google wants to hire you, that's a change in fact, and that's permissible. So for the F1, basically you need an I-20 that's issued by the school. You take the I-20, you take some other documentation to prove your intent, to prove that you have funds to cover your stay in the US, to cover your costs of education. You file with If you're already in the US, you file with USCIS. If you're abroad, you would file with the consulate and seek admission as an F1. All right, so that's your F1. The J is kind of similar, except it's more of a trainee type of visa. It could be for a researcher, it could be for a visiting professor, it could even be for certain nannies and au pairs and so forth. So it's usually limited to 12 to 18 months. It tends to be restrictive. It also requires a non-immigrant intent. And a sponsor is always required for the J1. With the F1, going back to the F1, you can basically come here because you want to study. No third-party sponsors required. The J1 requires a sponsor, whether it's a company, a school, or some organization that wants you here to allow you to permit you to take on the training. All right, so the J1 trainee, limited duration. Again, intent is that you have the intent to go back. H3 is another trainee visa. It's called the trainee visa. This, again, requires the intent to go back on the part of the individual, but it also requires a showing that the training that you're going to get is not available in your home country. So if you're going to say, I'm going to come in to learn about IT, it may be a challenge to say that, I can't get this training in India. Right. So the idea is that the training that you're going to get in the US is distinct. It's unique, and it's not readily available in your country. And the intention behind it is you're going to take this, you're going to then use it abroad. You're going to use that knowledge abroad for employment purpose. So again, the intent is there that you're going to go back, and you kind of have to show that. All right. The E3 now, again, that's as you see on the screen, it's usually for 2 years, so 18 months, 2 years, depends. The less the duration, the easier chances of getting the approval. The E3 is very similar and parallels the H-1B, which I think a majority of us probably already know. It's a specialty occupation visa. It's a treaty-based visa specifically for Australian nationals. The great thing about the E3 is there's no lottery. Pretty much there's always an available visa. So if you're Australian national, you have an Australian passport, you have a bachelor's degree, you can potentially be hired by a company to work in a specialty occupation capacity that correlates to your degree, and you can, get in. Basically, it's an H1, but it's called an E3 because it's for Australian nationals. All right, TN. It's not exactly like the H1, but it's for a certain number of enumerated professions. The TN, there's a list. If you're national of Canada or Mexico, you may be potentially eligible for the TN. For this, you have to show that the position that you're seeking in the US is on the list of enumerated positions. There is also the requirement for a sponsor. That there's a sponsor available, and it's usually for professionals, typically requiring bachelor's degrees, although the degree requirements are also specific. For a TN, if you're national of Canada or Mexico, best thing to do is to find the TN list, see if it's in one of the positions that you may be, looking to engage in, and then look at the qualification and then see if the correlation is there. It can be pretty easy to get if you meet the qualifications, but again, it's sponsor based. H1B1, very similar to the E3 as well as the H1B. It is basically the H1B for Chilean and Singaporean nationals. Again, it's a specialty occupation visa. You need a bachelor's degree in a particular field that correlates with the position that the company wants to hire you for in the US. And of course, you have to be a national of Chile or Singapore. No lottery is again required. It's a fairly much straightforward process, similar to the E3, the TN. Those tend to have a fairly, straightforward process as long as you meet the basic requirements of the position. And anything you want to add on this, Poonam, Sunita?
Yes, I just would like to clarify Australian and Canadian and Mexican nationals. What this means is that you could be Indian born, but have acquired Canadian or Australian or Mexican nationality and have passports from those countries, and you would be eligible for the E3 and TN categories, just as a matter of clarification.
It's not based on birth.
Correct. Moving on. Yeah, no, I don't have anything else. Moving on, as most of the people know about H-1B, but I'm just going to cover it very briefly. H-1B is available for anyone from any country at any level in any industry. The only requirement for H-1B is that the position must require at least a bachelor's degree or equivalent. It obviously is subject to a lottery. The lottery just opened this year, for this year on March 6th at noon, and is going to end at noon on March 22nd. The lottery process is once this year, the government's changed the lottery process, and each individual is going to be counted only once, regardless of the number of employers that may sponsor them. Unlike in the previous years, when each entry was treated separately and an individual with multiple employers had a higher chance of success. And last year, the government actually caught on to this, and there were almost 800,000 applications, registrations submitted for a total of 65,000 slots. There is an additional quota for 20,000 slots for individuals who have completed a US master's or higher. But because of this potential fraud that some people engaged in or companies engaged in, the government pivoted this year and issued regulations that went into effect in March, whereby only the individual, each individual will be counted only once. The lottery results are anticipated at the end of March, and then the H-1B submission period is from April 1st to June 30th. If during that time the government does not receive enough petitions to fill the quota, then they may run a second lottery. In the years past, the first time the second lottery was run was a huge surprise for everyone, because never ever had there been a second lottery. But there has actually also been a third lottery that happened in 2022 because of COVID and numerous circumstances. We do not anticipate and expect a second lottery this year, let alone a third. But again, depends on the economy, depends on the number of petitions that get filed. Each H1 is an individual may be in H1B status only for a maximum of 6 years. The exception is if the individual is from India or China and has a backlog in receiving a green card, then they are eligible to extend the H-1B up until the time they receive their green card. So for Indian nationals, an H-1B can go on for well over 12, 15 years before they get their green card. So it's the 6-year limitation would not apply because of the severe backlog for Indian nationals. Similarly, their spouses are not allowed to work during the 6 years, the initial 6 years. But once they have a green card process pending and they've reached certain milestones in that process, then their spouses become eligible for work authorization. And we'll go into that piece further down in the deck. I'll turn it over to Hafiz to talk a little bit about the L1, and then we'll go back.
Great. Thanks, Poonam. So the L1 is what's called an intra-company transferee. The L1A is for executives and managers. The L1B is for what's called specialized positions, specialized occupations. All right. So basically, the requirement is that there be two companies. There's a company abroad, and then there's a company in the U.S. The relationship between the two companies have to be that of parent to subsidiary, parent affiliate, or two affiliates of another parent, or a branch office. The idea is there has to be a relationship between the two companies. It's a transferee position. So the additional requirement is that the two companies have to obviously have the employment needs in the U.S. to transfer the individual to the U.S. So the individual being transferred has to have worked for at least 1 year within 3 years from the transfer, at least 365 days. Any time that the individual may have spent in the U.S., let's say visiting, is subtracted. So if somebody was working for a company for, let's say, 16 months, but spent 4 or 5 months in the US visiting, that has to be deducted potentially and could impact the eligibility. So the individual is working for at least 1 year as an executive, as a manager, or a specialized capacity abroad, can then be transferred to the US to the affiliate, subsidiary, or branch office. Both companies have to continue to be engaged in operations, what the USCIS calls systematic operations. The additional requirement with the Ls is that where usually USCIS focuses a lot is, was the position truly executive? Was it truly managerial? And will the position in the US be truly executive or managerial or specialized? That's where a lot of the issues tend to come up. Executive is somebody that's making policy, strategy decisions. It's kind of like the general in the military or a president and so forth. They're not doing the production work. They're not doing, let's say, the coding. They're not doing the writing. They're coming up with the bigger picture. They're sitting somewhere in the background making creative decisions, strategic decisions, long-term policy. Okay, a senior manager could also qualify, and that's called an L1A manager. It's a personnel manager, basically. Managers typically are required to have overseen at least 1 or 2 subordinate managers or junior managers, in addition to some other personnel who relieve them from non-qualifying duties. The idea being, again, that the individual manager or executive isn't doing the production. They're not doing the coding. They're not doing the writing. They're not doing the programming. They're managing something. And they're relieved from these production duties or the implementation tasks themselves from others. So you're looking at an org chart. An org chart is very critical when it comes to L1As. The individual looking for the L1 should be somewhere towards the top with a number of boxes towards the bottom representing other individuals, including 1 or 2 managerial and production individuals who relieve them from non-qualifying. All right. With the L1B, let me just step back. And the idea is in the US, once transferred, the person will occupy a similar position, that they will be truly functioning as an executive or a manager. So you have to have the org chart showing that the person on day 1 will be relieved from non-qualifying. They can't come here and do programming as well as manage. That wouldn't work. They have to be strictly managerial or strictly executive. The only instance in where you could have a little bit of a hybrid mix is what's called a new business L1. That is that requires that the U.S. company be newly established less than 12 months. So if you have a company that was a new office, for example, established less than a year ago, you can transfer somebody to come to the U.S. to spearhead the U.S. office and lead the U.S. towards developing the new office. In that situation, you have to have a business plan that shows that within 12 months of the transfer, the individual will be relieved from the non-qualifying, that by 12 months, we will have built the structure to such a situation where the individual is not going to be doing non-qualifying duties. All right, so that's the new business, new office L1, where it does allow for some flexibility as long as the company is less than a year old, provided you can show the company has the ability to truly, support the managerial position within the 1 year. The L1B is specialized knowledge. That's for individuals that have certain unique skill sets, certain unique proprietary, sometimes though not necessary, certain knowledge that is very pivotal, very critical and crucial to the foreign company. Perhaps it was gained through years of employment, through certain confidential training, through certain processes that are not readily accessible by anyone, that you can't take somebody, with some work experience somewhere else and then let them just come in and qualify. It's somebody that's kind of been groomed for that position, has the unique skill set, and based on that, they were working abroad, they're qualified for that position, and that they're looking to do something similar in the US. So in that case, they can be transferred, but the 1 year requirement still stands. They had to have worked in similar capacity for at least a year prior to their transfer. The L1, like the H1, is what's called a dual intent visa. Anyone can come in with the L1 intending to get a green card. It's very clear. They don't have to hide that fact. It's open that they can seek green cards. In fact, the L1A has a potential that we'll discuss later to get expedited green card through the multinational manager EB1C category. As you can see on the chart here, the L1A is the duration is up to 7 years. L1B is 5 years. These are kind of fixed. Unlike the H, these can't be extended, but there are ways, if way to move around that if needed. But typically these individuals can get green cards, fairly quickly if you follow, certain strategies. Anything to add, Poonam, Sunita?
What I would like to add here is the L1 is far superior to the H1 in many ways. One is there is no lottery. The other is the spouse is able to work.
Yes.
And the third is that the path to the green card is a lot shorter, because as you will learn from Poonam later on, those filing for the green card as multinational executives or managers will come under the EB1C category, which, if you look at the priority dates, is not as backlogged as the H1 is. So as a matter of strategy, if there is a company that wishes to import some H1s from a certain other company overseas, an acquisition is often considered and worked, or some sort of a merger agreement between the two companies to make them eligible for L1s if the numbers are large enough, so that you can, then reap the benefits of the better visa.
Absolutely. I don't have anything else to add on L1, and also being mindful of time, we're almost halfway to our allotted 1 hour. So just moving along, we'll cover the rest of it fairly quickly so we can get to the questions. O1 category is for individuals that have reached the very top of their field and have been recognized as such, whether it is through a national or an international award or through certain criteria that they meet. It was originally intended for and typically used for individuals in the research arena, for the scientists and so on. But O1 is available for individuals in the business as well. And we've successfully used that in that category. E1, E2 is, and moving very briefly through this, is available for nationals of a treaty country. India does not have a treaty with the US. It's been on hold or in negotiation for 20 plus years, and it's stalled because I believe there is no reciprocity available for a clear path to green card under E2. So the Indian government has been reluctant to sign this treaty. Moving on, we'll move on very quickly to the paths to permanent residence. We'll cover the traditional and the alternate paths. The traditional path is someone may come into the US as a student in F1 status, get picked in the H-1B lottery, and then get sponsored for the green card. The green card process is the PERM process, which is essentially a labor market test that a US employer has to go through to test and confirm to the Department of Labor that there are no qualifying US workers available. Once the labor market test is completed, then the company can sponsor the individual and say, because there are no qualifying US workers, we would like to sponsor this individual. And then the last step is for that individual to apply to receive that green card. For Indian nationals, the gap between the last and the second to last step is enormous because of the tremendous backlogs. That is where the biggest backlog is. The PERM process itself is not a hop, skip, jump process. It is currently about 2+ years to complete from start to finish. So this is a long-term strategy, and the sooner someone gets in line, the better it is for them. So that's one. Individuals that are in other statuses other than H-1B can also apply for perm and go through this process, similar to L-1B, TN, or E-1, E-2, or E-3. Any of them can go through the perm process and get to the green card. The L-1B is different than the L-1A, and I'll turn it over to Hafiz to talk about that distinction.
Thanks, Poonam. So the L1, as I mentioned earlier, is for an executive, L1 executive or managerial. The B is for specialized knowledge. The B doesn't lead to the direct, the EB1C, because it's for multinational managers. And obviously the specialized knowledge is not a manager. So the L1B individuals usually have to pivot to maybe becoming an L1A and see if they somehow meet the EB1C requirements, or they might have to go to the perm route and get the green card through that process. The O1, I believe, if they're very qualified, can go through the EB1A route, which is the outstanding ability and extraordinary ability individuals. This is can potentially lead to a green card even without a sponsor, depending on the individual's abilities and the category in which they file. It's a case-by-case inquiry we have to look at, but potentially they may qualify, including through the EB to NIW, which I think Poonam will be discussing in a bit. Poonam, anything you wanted to add?
No, just one piece that, as you mentioned, O1 does not require, if you're using the O1 to the green card process, it does not require sponsorship from any company, but every other category requires sponsorship, requires an employer to sponsor the individual for the green card. There are only two categories that do not require that sponsorship. One is the extraordinary ability category in the first preference, or the national interest waiver in the second preference, which is what we're talking about here. Any individual in any visa category, including the F1, can apply for a green card and self-petition for their own green card under the national interest waiver category. The national interest waiver is for individuals that are working in a field that is so critical for the US national interest or economy or whatever, that it is in the US interest to waive the requirement for a job offer, which is typical for an employment-based green card, as well as waive the requirement for a perm process or a labor market test, because their work is so critical. The Biden administration earlier this year released a priorities memo that they are going to, the STEM fields are a huge priority. So anyone working in the STEM fields have a huge advantage in applying for an NIW and going through this process right now.
Just as a minor note, the NIWs are getting approved quite easily. And as Poonam pointed, particularly in the STEM fields and in healthcare as well. So it's something to note for our particular group here.
Yeah. I'll turn it over to Hafiz to talk about the EB5 process very briefly.
Sure. Thank you, Poonam. So the EB5 has seen, I think, the greatest interest in the last couple of years from Indian nationals due to the severe backlog in all the other categories. It's a great option provided you have the funds. You're looking at least 800,000 if you're dealing in the traditional what's called TEA areas, or $1.05 million in other areas. So two routes to the EB5 is when you do your own business, you start your own business. That's called a direct EB5 investment. So let's say you want to, you're working on an H and you want to open up your own software consulting company. you can do a direct investment, open up an entity or acquire an entity, create 10 new full-time jobs, make the requisite investment, and potentially through that you can get a green card. Right now you're looking at 5+ years. I won't be able to give any more details in terms of the numbers because it's been fluctuating significantly, but let's say minimum of 5 years, 5 to 7, definitely less than other categories, but that's one way. The other option is through a regional center, where you give your funds to another company which has already done some filings with the USCIS and gotten approval to qualify as a regional center and had their project vetted. And through that, you can potentially get a green card. The good thing, the best thing that happened to the EB-5 world lately is that you can do concurrent filing of the EB-5 and the 485. This was not possible until about 2 years ago. So what that means is if you're ready to invest in one of these categories that are potentially current, and there are several categories that are current, you can make your investment and file the EB-5 I-526 along with the 485 concurrently, and then you can get on the road to, sit on the I-485 adjustment track until the green card actually catches up. Once the I-526 is approved and you get your green card, you get a conditional card good for 2 years. After 2 years, you need to then file, well, before 2 years, 3 months period before the 2 years, you need to file another application to remove the conditions to get the permanent card, and that's called the 829. There, you're required to show that you've actually completed the underlying obligations, the full investment has been committed and sustained, and the jobs have been created or will be created within a certain immediate short run from the filing. And after that, you're eligible, to get the permanent card, basically. So that's the additional route outside of the PERM and EB-1A and EB-1C.
There's just one additional piece I wanted to mention that we did not put on the slides. For an individual to start the business in the US, there is an alternative path that is outside the realm of these visa categories, and it's called an international entrepreneurial parole. It is not a visa category, but it is a parole that is valid for up to 2 years. An individual can come in, start the business in the US in that status, and then pivot to a traditional path after that. So I just wanted to put it out there. And we're mindful of the time, so we'll move on and talk about layoffs, because this is a hot topic, and this is something that unfortunately a lot of people have been impacted in the last couple of years. So the big piece for this is maintaining status. Anyone who is subject to a layoff in H-1B status has a 60-day grace period. Other categories do not have such. I believe they do as well. They do have a 60-day grace period, but at least the H-1Bs have a 60-day grace period. 60-day period is actually a pretty short time for someone to just wrap up everything and move, or even get a job sometimes. So there are different strategies that we can employ depending on what the circumstances are, what the facts are, where things are, and what their personal situation is. But it's critical that anyone who is in this situation consult with an attorney before simply switching to a B2 and thinking that's just okay. It may be okay, it may not be, but it depends on your situation and where you are. Then we want to move on to the impact to the green card process of a layoff. One is a direct impact, and we'll talk about that, but there is an indirect impact of a green card process. So the individual may have layoffs in the company. They may not have lost their job, but because there were layoffs in the company, their green card process can get halted because the company is unable to proceed with the PERM applications and make certification that they're on the PERM process to that effect. So just something to be mindful of that as well. The direct impact of a layoff is if someone is subject to a layoff, but they have an approved I-140 that is more than 6 months old, then their priority date is safe. They are okay, that that is fine. Whenever they find new employment, they can still rely on that green card process and come back to it down the road. The ones where the maximum impact and really truly unfortunate situation is where either the I-140 has been approved for less than 6 months and the person's laid off and the employer withdraws that I-140, then that entire process is nullified. Or the I-140 is pending, or the perm process is pending and they are laid off, then again, that entire process is for naught. The person has to start over with the new employer. As heartbreaking and unfortunate as it is something that comes up too often than we would like to see. But this is something that to be mindful of, and we get questions on this all the time. What's happening to my green card process? I'm here. So, and we can address any questions after during our Q&A session on this. So Hafiz, I'll turn it over to you to talk about sponsorship of family members.
Great. Thanks, Poonam. So yes, if for those individuals that are lucky enough to have family that may be able to sponsor them, that's another route to the green card. So green card holder, LPR, lawful permanent resident, can sponsor a spouse and a child. For immigration purposes, child is usually considered someone under 21. Once they turn 21, then different things come into play. A different analysis needs to be done. So the green card holder can sponsor a spouse or a child, but you have to look at the priority dates and see, what date is potentially current right now or not current. And then it may become a two-step process. If the individual's outside, you have to wait until the date becomes current. They're already here. They'll have to maintain whatever other status they're already in. USC means U.S. citizen. They can sponsor their spouse. They can sponsor for a fiance. They can sponsor children, even over 21, and parents. Very, very important. USC parent or USC's spouse are what are called immediate relatives. There's no visa quota that applies. They're immediately eligible. As long as these individuals have made the last entry that they made was lawful, they entered the US lawfully, even if they're out of status. Even if for 10 years these people are out of status, they can still get their green card in the US. Other analysis apply in terms of whether there's been violations or unlawful presence, but typically if they had a lawful entry, and even if they're out of status, they can get their green cards in the U.S. and the wait time is negligible comparatively. USCIS siblings, that takes a long time. We're looking at 15 plus years, some cases even more. What that requires is the USC file and then wait until the date becomes current. The good thing with the sibling petitions is it covers everybody, covers husband, wife, and children under 21, and potentially even more than 21 if they're covered under the CSPA, the Child Status Protection Act. So where this is possible, it doesn't hurt to get an application in, plant the seed, and wait for it. Time flies, you never know, it catches up, and then it'll be able to have the whole family come in. We just filed something for siblings that waited for 12-15 years, but unfortunately the petitioner died, but there was still a way to rescue it, and then we're working on bringing them over. So this is something where this is eligible, where this is possible, doesn't hurt to consider it and file it as a backup. Financial obligation. In any immigrant sponsorship where there's a family member sponsoring, there's always what's called the I-864 obligation that you're assuring. The U.S. person is assuring that the foreign national and their family will not become a public charge, for 10 years or until they become a citizen. They should not go on welfare. They should not go on Medicaid, although there's some exceptions for emergency matters. But the idea is that you're sponsoring them and you have to show you have the ability to cover for them that they will not become a public charge, among other requirements. But that's the family categories in a gist.
Great. And we very, very briefly want to cover the B1, B2 and what's permissible on B1, B2 for individual visiting from the US. They can attend conferences, obviously tourism. We did not list tourism here, but they can definitely come to visit and be, just enjoy and sightsee and all of that. But from a business perspective, they can participate in business meetings, negotiate contract, attend conferences, but they cannot work for their employer that is outside the US, sitting in the US in B1, B2 status. The consequences can be severe. How often does it get tracked or flagged? It may not be flagged when the person engages on that behavior, but it may be flagged down the road. And the visa can be revoked, the person can be expeditedly removed and turned around at the airport. And it is not a pleasant experience, I can assure you of that, and would not wish it on anyone. So with that, we will end our section of the talk. But we're here if anyone wants to ask any questions, and we can stay a little bit over as well if needed.
Just one caveat though on the B1, B2, there are many companies that sneak in workers that they would otherwise like to have on H1B on B2 visas. And that really ought to be discouraged as much as possible, because the consequences can be severe. We have seen quite a few cases where people have been deported because they've come here and done performed what is deemed unlawful work. So anything that enhances the productivity of the entity, the US entity, is considered productive work and is considered employment. So one should be very, very mindful of that.
Okay. Great. Thank you so much, Sunita ji, Poonam ji, and Hafiz ji. Excellent presentation. It was very well structured and very simple to understand. I have been here for decades, but there are things I learned today which I did not know. So thank you so much. So for all the participants, you can raise your virtual hand, physical also, but that I won't be able to see it. But your virtual hand at the bottom of your screen, you will see that. I can see Ayush has raised a hand, and the other people also. Please. So the way I will do is I will first read the questions that have been already sent to me earlier, and then I will give chance to the raised hands, and then we can ask anybody else request. So the first question I received was, it says, I have approved I-140 EB2. Priority date is in late 2022. Their daughter is age 17th, and she's going to college this year as H4 dependent. So first question is, what are the possible ways for her before she ages out of 21? And obviously this is because the backlog of the green card. And does your office provide help with H4 to F1 status change and guide through the process? So these are the two questions asked by this person.
Okay, Hafiz, you want to take that? A little, very brief explanation of CESPA, not too much detail.
Sure. So the Child Status Protection Act is designed to protect individuals like this, but it depends on how long the I-140 is pending. If the I-140 is pending for 6 months, basically you can subtract 6 months from the child's age at the time that they would be able to file the next stage of the application. If that doesn't help them, then basically the child will age out. All right, that's just a very quick synopsis of it. We have to look at it case by case. Most likely, I think this child, Poonam, correct me if I'm wrong, probably will not make it in this category. In terms of changing to F1, that's fairly straightforward. They would need to get an I-20 from the school. The I-20 start date usually is recommended that it's within the 30 days of the status expiry before they turn 21. The application must be filed before the child turns 21, because on the day the child turns 21, the H4 drops out. So we don't want to break the status. Make sure that that's filed before the child turns 21. By filed, meaning that the application with the proper receipt and documentation is received by USCIS. Okay. We do handle these regularly.
Okay. Yeah, and your contact information is right there. So the person who asked the question,
correct. Poonam, if you wanted to add anything to that, please.
No, I mean, I'm mindful of time. I think if there's specific questions we can answer in a consult, but for the purposes of general knowledge, I think this covers it. So we can go to the next question, Rahulji.
Yeah, I just want to ask one more thing. You mentioned I-140 pending, but in this person's case, it's approved already.
Correct. But for the calculation that Hafiz was talking about,
Mhm.
it's a slightly nuanced calculation, and the time period that the I-140 was
Was
pending
pending.
determines how much
Oh.
time the child has.
Okay.
That you can
Okay.
subtract.
You can recapture the time that the I-140 was pending.
Correct.
Okay.
I mean,
Great.
this is after it was approved, but the daytime it was pending is all that will help
Mhm.
the child. And as Hafiz mentioned, in this case, probably it's unlikely that the child would be able to
Okay.
adjust status with the family.
Okay. Okay. Yeah. And again, if they have any specific nuanced questions, they can always contact you and get consulting.
Right.
Absolutely.
The next question is from someone who is, I think, in Canada or maybe trying to move. It says, can someone, Canadian citizen, fall in EB1 category for green card if they are on L1 visa? L1A, they mentioned.
Yes.
Sure.
Yes, we covered this during our presentation.
Yeah.
So if there's anything more beyond that, then we are happy to look at the individual situation and come back.
Okay.
I just wanted to add that Canadian citizen is also eligible for an E2.
Oh,
If they wanted to come here and do something here in the meantime, while they explore the green card, they could seek the E2.
okay. The next question from the same person is, and I think it was probably covered in a different manner. So, can someone sponsor their spouse? They didn't mention whether for green card or for visa. If they are on L1 visa, and if yes, how long does it take?
Yes, the answer is definitely yes. They can sponsor their spouse, and how long it will take will depend on whether they are here in the U.S. Or whether they're overseas and consular processing is required. In which case,
And the
dates-
nationality of the spouse. If
Oh.
the individual is Canadian and the spouse is also Canadian, then it's fairly easy. But if the spouse is non-Canadian, then it may take longer. So again, very fact specific,
Yeah.
and we would need to see more.
Okay, that's great. I was looking at the chat. There's no question on the chat by anybody. So I'm going to the raised hands, and Ayush, please unmute yourself and you can ask the question. Anybody else who wants to ask question, please raise your hand. I'll go by the queue. Go ahead.
Thank you, Rahul sir, and everyone. This question is not about myself, but I was trying to bring my sister for a visitor's visa, and her visa got denied. So, question is, people suggested that I have to give a invitation letter so that it will help in the next time. Does it help actually, or it's just a myth?
It does help.
It does help.
Yes.
And Ayush, just one more thing. Sometimes it is helpful to have a consultation with an attorney and
Okay.
do a prep session for the interview, because at the end of the day, what matters is how the person presents themselves at the interview. Because what
Okay.
they say and how they say it determines, I mean, the officer only has no more than 2 minutes. The officers at the consulate are tracked and timed for how long they're taking on each application. If they take more than 2 minutes, they are dinged and get called out and pulled to task. So they only have 2 minutes. They have to make a determination. Saying no is easy for them. So how the person presents themselves, so the officer is inclined to say yes to granting the visa, that is something that may also be helpful.
And also, Payush, another thing, financial ability is one aspect of it, but there are various other factors. Ties to the home country are
Correct.
very important. That may be a more important factor. So if this person is young, unattached, no family, no property, no assets, then even if you sponsor him or her, the likelihood of getting approved is very slim. On the other hand, if they are a family with children, with assets and other ties, they have employment and good employment in India, then the likelihood of approval is higher. So we need to assess the situation in its entirety, before saying what should be submitted and how it should be submitted.
I just wanted to add to Poonam's point, presentation is key in these kind of cases because how you present the case is going to make a big factor. It's very discretionary, and especially if there's a denial already, the second one is already an uphill battle.
Correct.
Thank you very much, both of you.
Excellent. We have Majid Khan sir who raised his hand. So
Um, Sunita ji and Associates Hafiz Poonam ji, thank you very much. My just question is, one is, what is the for the investment when you do it here, and what is the investment amount right now to get the green card, to get the citizenship for business?
A green card, it would be, Majid.
I'm sorry.
It would be for the green card.
Okay.
yeah. First step is green card, right? Then only citizenship.
Yes.
Yeah. So, Hafiz, that's your subject matter.
Sure. It's 800,000 if it's in what's called a target area. Target area is an area where there's a high unemployment. Usually it's 150% of the national average. So it's 800 in that situation. Otherwise, it's 1,050,000 elsewhere. That's the investment requirement. And the other part is that this investment will ultimately create at least 10 full-time jobs.
Yes. So do they also publish the target areas, or we have to find it out, or we have to let them?
You can find there's ways to look at the target areas. In the past, USCIS used to defer to the analysis from, let's say, the local government, state agencies, and so
Yeah.
forth. These days, what you have to do is basically provide your analysis, usually from certain commercial sites, as well as an economist, and then show that it qualifies, and that becomes part of the adjudication. They're going to look at it and see if they agree that this is a target area. So,
Okay.
yeah, but there's ways to get a preliminary understanding as to whether the area qualifies or not.
Okay, so also, Hafiz, are there any consulting firm that can also help us to making sure that the target area is approved?
Yes, there are commercial services available that
Okay.
can do the preliminary analysis, and you'll get a, mostly they're accurate. They will be accurate that the area would qualify. I guess you're talking about a direct investment where somebody wants to make.
Yes.
Yeah.
Yes.
May I ask what national from where were they born?
India.
Okay. Yeah. So yeah, they would want to go to like a potentially a rural or high unemployment area. It'll be faster for them. And there are ways to get a pre-screening as to whether an area qualifies.
Okay. Thank you. Thank you very much. Thank you.
Sure.
Thank you. The next is Saurav Guha who has raised a question. So Saurav, you can ask your question.
Yeah, hi, this is Diksha. I'm asking a question on his behalf.
Okay.
So, hello everyone. Actually, I had a question. So, my in-laws come every alternate year and they stay for almost 175 days. They're on tourist visa, and our green card application is in process with the priority date of 2018. I had a question. So, when we file our tax return, we claim them as dependents on our return. They have their own ITIN numbers. So will it create a problem when we get our final green card during the? I've heard vaguely that they go through all your tax returns and financial statements and see whom do you claim as dependents. So will it be an issue at time of when we get our green card?
So, Diksha, your green card is through an employer.
Yes.
So your tax reforms will only be scrutinized at the time you apply for citizenship, not at
Okay.
the time you apply for the green card. At that time, the employer's tax returns will be looked at to see if they have the ability to pay you.
Okay.
I cannot opine on the tax consequence of it, whether it's permissible or not. But from an immigration perspective, it should not be an issue.
Okay. And when we apply for our citizenship, and then once we get it, whenever that happens, we apply for parents' green cards. At that time, do they scrutinize that?
It may come up. It may.
Okay.
If I can
Right.
add, I think this goes towards what Poonam was suggesting. It goes towards character ultimately at the citizenship stage, whether you've done something potentially inconsistent with your tax status. So you want to defer to your accountant and make sure that what they're doing is appropriate. That the deduction or the exemption, you're truly eligible for it. If not, they could raise that saying that you are taking improper collections, and it goes towards character down the line.
Okay. Got it.
Okay. Thank you.
What is
Very
the
Makes
what is the duration of their stay in the US, if I may ask?
Under 100.
So it's less than 180 days. So we try to keep it between 170 to 175 mostly. It hasn't gone across that.
And
They've
your
been here.
accountant is okay with you claiming them as dependents?
Yeah, we've done that twice.
I see.
Okay.
Yeah.
Yeah, I think for further detailed thing, you can probably
Yeah,
approach the
maybe we should.
accountant and
Yeah.
Okay.
okay. Thanks,
Right. Sounds good.
Disha, for asking that question.
Thank you.
Nindya Tiwari, you are next in line. If you're in India or somebody else on her behalf.
Thank you, Rahul sir, and thank you, Poonam. So my question is, how is E1 different from TN1 visa for Canadian citizens?
E1 versus TN. So E1 is
Very
for
different.
right. They're completely different. A TN requires an employer. You're going to come work for an employer in designated occupations. And E1 is for trade between US and Canada. And you are conducting trade within the two countries. And E2 is if you're investing in a business in the US. So it's completely different. It's your own business versus being employed by someone on a high level.
I think what she's trying to ask is, are you an employee that with a Canadian company that is eligible for both TN and E1?
I'm not sure on that. I work for Electronic Arts. So, I mean, yes, they should be eligible for TN1, obviously, but I'm not sure about E1.
Okay, because if you're eligible for both, then E1 would be the better choice.
Okay.
But we can talk about that, in more detail if
Yes.
you like.
Okay. Yeah. Thank you so much.
Great. The last hand is Kinshuk Tiwari. Go ahead.
Hey, thank you, Rahul sir. Thanks, Poonam and team. My question is, so I work as a senior executive for my company, and I've been working for them for the past 9 years or so. I'm on an H-1B. I have an I-140 approved, and my GC is filed in, EB2. But I haven't worked for this company outside of the US or for any of its subsidiaries, outside of the US. And my role kind of coincides with an international manager, except for the fact that I have not worked outside of the US. So is there any provision in the immigration laws right now which would allow me to upgrade my petition to an EB1?
So there are two ways. One could be that you go work for that company outside for 1 year and come back in L1A status, and then at the same time apply for an EB1, multinational manager. That is one. The other is if your contributions rise to the level of extraordinary ability in the business, then potentially that is also an option. But again, we would need to do a much more detailed assessment than we can discuss here. But those are definitely two options, and we've successfully done both multiple times.
Okay. Anybody else who wants to ask a question? Because that was the last raised hand. We have slightly above over 1 hour. So I think that's fine. If anybody else wants to ask a question, please raise your hand so we can include you. Going once.
So, Majid, what we could do later on is we could talk further about the EB5 option if you wish to consider that more seriously for people you know.
Absolutely. We can definitely send this. And Sauraj has asked a question just in time. Sauraj, go ahead.
Hello, everyone. Thank you for the presentation. Just a quick question: if a person is possibly eligible for EB1A, 1B, and O1, which path should they pursue? Which would be the better path?
And O1 would be the non-immigrant. It is not going to get you the green card. EB1 and you said EB2? I'm sorry.
EB1A, 1B.
EB1A or EB1B does not matter. They're both the first preference. If you have the ability to do EB1B, then that might be slightly less stressful or slightly easier than EB1A.
But I think what is critical here is whether you're looking for a non-immigrant status or you already have non-immigrant status and you're looking for a green card. Because if you're looking for non-immigrant status, the O1, while the requirements may seem very similar to the EB1, are actually a much lower threshold, so much easier to satisfy. So the O1 would be a good first step if you need a non-immigrant visa. And then you can build and sustain that extraordinariness for a year or two or more, and then go for the EB1. The strategy would depend on, would be really tailored around what you require.
Okay, I understand. Thank you. Yeah, it's already on the non-immigrant status, so I guess EB1B and then EB1A would be the.
Yeah.
Okay.
Absolutely.
Thanks, Sauraj.
Thank you.
Anish Sajan has raised a hand. That will be the last question, and then we can wrap up. So Anish, go ahead. You have to unmute, Anish. Okay. Maybe having some technical difficulties.
Yes.
So I think what we can do is we can wrap up this. And Anish, if you have any questions, you can directly contact. I think he probably left and he joined. Anish, are you there? If you are, unmute and ask the question.
I think he just rejoined.
Yeah, I think he rejoined. Maybe technical difficulty. So I think they can always contact the company. Their number was there, and it will be recording. Recording will be available, so they can always catch it. So I just want to say thanks so much for your presentation. It was very much to the point and to our desire that all the people look for. And thank you so much. I would like to ask Majid sir if you have anything to say in the closing, and then I will stop recording, and then we can slowly exit the meeting. Majid sir, if you would like to say something.
Rahul, may I just take a few seconds to re-emphasize that this seminar was for informational purposes only.
Yeah.
Not to be construed as legal advice.
Absolutely.
If there is legal advice required, we're happy to provide that at a later time.
Absolutely. And when we post it on the recordings page, there we always say that these are all for just information purpose only. Any serious discussion has to be done with the presenter directly.
Yeah.
Great.
Yeah, absolutely. Majid sir, aap kuch kar rahe the?
Yes, Sunita ji and Hafiz and Poonam ji, thank you very much. With this talk, I think we have started a new chapter with you, and we have a lot of families, nice families. They'll be seeking help. So I really appreciate your time, and this is sort of like will be the ongoing process with you as associates for us to help us out. And I really like the way that you have. I know I've been a citizen since 70s or so. A lot of things have changed. So again, thank you very much, and we will be in touch with you. And I encourage everyone, just make sure that if you can seek help, go to Sunita ji and her team. And with that, I really thank you very much again and appreciate.
Thank you.
Thank you, Majid, for having us. Thank you, Rahul, for organizing this. It's been a real honor to speak to the group. It's a very well-known, prestigious group. So we do appreciate being invited. Thank you.
Thank you so
Thank
much.
you.
So I'm going to
Thank
stop
you.
recording now. And yeah.